May please, Lordship, for listing the writ petition, motion, Lordship.
When do you want it?
Lordship, on Thursday, Lordship.
My pleasure, Lordship. Lordship, I beg to mention for listing of admission.
Next week. Next week.
May I please, your Lordship? Lordship, I am praying for listing of a writ petition, Lordship. May I pray it on this Friday, Lordship?
Do it next week.
Okay, Lordship.
May I please, your Lordship? Consent taken from all parties for Lordship. I am making mention for adjournment item number 9, Lordship.
Item number 9.
9, Lordship.
What do you want? You want adjournment?
May please,
Adjournment.
Lordship, for listing the writ petition, motion, Lordship.
When do you want it?
Lordship, on Thursday, Lordship.
My pleasure, Lordship. Lordship, I beg to mention for listing of admission.
Next week. Next week.
May I please, your Lordship? Lordship, I am praying for listing of a writ petition, Lordship. May I pray it on this Friday, Lordship?
Do it next week. All right. Looks like some ghost. Okay.
Item number 9, Lordship.
Yes, you are for?
Adjournment, Lordship. I am for the petitioner, Lordship.
Acha. With the consent of the opposite party, Mr.
JM Google, Lordship.
J.M. Gogoi, learned counsel for the petitioner, seeks adjournment in this case with a prayer to post the matter again after 2 weeks.
After 2 weeks, Lordship.
After 2 weeks.
Obliged.
Since the prayer is not opposed, same stands allowed, list accordingly. Yes.
Mayor, please, Lordship, listing for incumbency for admission. Next week, any day.
Yes.
May I please, your Lordship? Beg to mention WPC 8211 to 2022 for listing, your Lordship.
Next week.
Item number, Lordship, item number 15. Item number 15.
Yes.
Advocate not present. Engaged advocate is not present. Listen after 2 weeks.
No, then we'll release it from part heard then. You are for whom?
Petitioner.
On the prayer of learned counsel for the petitioner, hearing of these matters stands adjourned till 31/7/2023. List accordingly.
My lord,
Hearing of these matters 15 to 18.
my lord, may I listing of this matter on Tuesday next. Lordship matter came on 6/6/2023, my lord, before my lord. So Lordship, here affidavit has been exchanged, my lord. Well, Lordship fixed it after 10 days, but that hasn't been listed. Person is going to be retired on 31st July, my lord. Whatever the order may, in the Tuesday next, my lord, if your Lordship.
All right.
May please, my lord, item number 8, my lord, there is a typical mistake in the affidavit. Lordship, may allow to be correct.
Typographical mistake in the,
In the affidavit filed by the respondent.
how can you correct it by hand? It is not permissible now. Let us see, we'll deal with it.
Lordship.
About the list, item 1.
May it please, your Lordship.
Yes.
In this case, my lord,
Hmm.
petitioner in the year of 2009, my lord, there is an advertisement and petitioner appeared the interview. Interview was withheld, my lord. And the petitioner challenged this, my lord, withheld, my lord, page, my lord, 17, my lord. And next page, page 18, 26, my lord, Morabari, my lord, withheld, my lord, Morabari Bosti, withheld, my lord. So she also filed an application for my lord declaring the result. And thereafter, my lord, I personally, my lord, file an application to RTI, my lord.
So you appeared in interview in 2009.
my lord,
Now, list should be declared and you should be appointed.
my lord,
You know that that prayer cannot be granted. Don't
my
you?
lord.
You are aware that that relief cannot be granted now. After 14 years, it cannot be
But
done.
one thing is that till today, my lord, till today, this.
Why,
post-
what is the matter?
My lord, in this matter, we haven't filed our affidavit, but my lord, uh, my friend has just supplied me an RTI reply that he has received from the department, my lord. There
Can
is a
you use
report
the
of-
microphone, please?
It's on video.
My lord.
Hmm.
So, my lord, he has supplied me with an RTI reply. So, my lord, this reflects that, yes, she appeared and she was within the vicinity of that area, my lord, of Anganwadi. But here, the pertinent question remains, my lord, still that whether a select list of 2009-10 can be valid in 23. It's a huge, my lord, passage of time, my lord.
My lord,
That is the pertinent question, my lord.
first my
and-
page 3, my lord. Page 3, this is the 2012, my lord, RTI.
Mr.
date.
Bora, how much time will you need?
My lord, I am sorry for that. Because of that, I prepared an additional affidavit, my lord. See,
You
is
make
the, my
your
lord,
submissions, then I'll dictate the order.
the maid servant, my lord, cannot be, my lord, he come to the Guwahati, my lord. So this is the record.
No,
Record
no,
say,
what is the relief direction to appoint you?
no, my lord.
Then-
I am praying for declaring the result, my lord.
That, how can we pass the direction?
So till today, my lord,
That
no.
result will be declared, but they cannot act on this list. That will make clear. 14 years back, selection process, that list cannot be declared or acted upon. today.
That is.
That's
correct.
the law. You are a very seasoned lawyer.
I know, I know.
Unnecessarily.
I
fluffing
know,
something.
I know my
Your
limit.
petition has become infructuous.
I know my
Mr.
limitation.
Bora is a good lawyer who should have straight away
I
said
know my
that
limitation.
petition
but-
is infructuous, close it.
but I
Instead
should-
of it, just take chances. You know the law.
I know, my
Why are you compelling the judge to write out an order in these
my
matters?
lord, in spite of the, my lord, till today, my lord, there is no.
Nothing.
appointment.
This will dismiss it. This cannot, it's over.
My-
2010, you file a writ petition, 12,
my-
11 years back. And the relief you are seeking, it cannot be granted. You should have mentioned it in the morning saying that this is infructuous.
my lord.
You want to
No, I am
put
not.
things off your back, that's all. So
My
take
lord,
your
just-
seat, let us.
Just I am going to point out before Lord.
Nothing. It cannot be done. We lay down the law, it
My
cannot be
lord,
done.
that observation may be given.
Take down. Heard Mr. N. Bora, learned counsel appearing for the petition. Also heard Mr. R. Dhar, learned additional senior government advocate Assam appearing for the respondent numbers 1 to 5. Full stop. The writ petitioner herein had participated in the selection process initiated by the departmental authorities based on advertisement notice issued by the respondent number 5 in the month of September 2009. Full stop. The petitioner had also appeared in the interview held on 10/12/2009 for recruitment in the post of Anganwadi worker at Murabasti Anganwadi Center at serial number 26 under the Bagmara ICDS project in Sanitpur district. Full stop. The grievance of the petitioner is that although the respondents have declared the results of selection process conducted for recruitment of Anganwadi worker stroke helper for the other ICDS, for the other AWCs covered by the advertisement notice issued in the year 2009. The results of the selection process undertaken for filling up the post of Anganwadi worker at the Murabasti Anganwadi Center at serial number 26 has not been declared till today. Full stop. Mr. Bora submits that the petitioner seeks a direction from this court upon the respondents to declare the results of the selection process conducted in the year 2009. and thereafter to appoint her as Anganwadi worker. Full stop. I find from the record that this writ petition was instituted way back in the year 2012, and there is no order of this court extending the validity of the select list. Full stop. Situated thus, comma, regardless of the performance of the petitioner, the select list, comma, if any, comma, prepared in the year 2009 for recruitment in the post of Anganwadi worker at number 26 Murabasti Anganwadi Center would not be valid after the lapse of nearly 14 years as on date. Full stop. Under the circumstances, no writ of mandamus as prayed for can be validly issued by this court, inasmuch as the respondents cannot operate select list, if any, prepared on the basis of interview conducted in the year 2009. Full stop. Although the respondents have not filed any counter affidavit yet, what do you want to show from the RTI?
My lord,
Last page, my lord.
the last page, there is a report.
Yeah.
But it's of 2012, my lord. The report is of 2012. That, my lord, indicates that she is from that particular area. That is there. But, my lord, still this RTA reply cannot overcome that, my lord, that there is a lapse of almost 14 years.
However, if the post of Anganwadi worker in the number 26 also is still lying vacant, it will be incumbent upon the respondent authorities to fill up the vacant post by following the due process of law. And if the petitioner is eligible for appointment in the said post as on the date of issuance of fresh advertisement, her case would have to be considered in accordance with law. With the above observations, this writ petition stands closed. You have understood?
I know, only for 1 year, I know.
Uh-huh.
Delay is only for 1 year, I know, but. I
You
have
want to
lots
take
of-
back this? You want to-
My-
Yes, next matter, please.
May please.
Lordship, the matter may be adjourned as Mr. P.N. Goswami is not available.
2012, top of the list matters cannot be adjourned. Yes.
The petitioner was initially a sub-engineer under the bank, my lord. The charge sheet was issued on the allegation that the petitioner assaulted one GM. One charge, my lord. Petitioner submitted his reply denying the allegation, my lord. Along with the charge sheet, my lord, no list of witness, no list of document furnished to us. Report to us.
1 minute, Mr. Koto, please.
Why would I approve?
So what are you challenging in this case?
In
Mr.
this impugn order dated, my lord,
Hmm.
13/6/12, imposing penalty of stoppage of 2 increment with cumulative effect.
Page number?
Page number 30, my lord. 30.
Yes,
What happened in this case, my lord? I have on the point of argument, my lord, along with the search sheet, no list of the witness, no document. The victim who was the complainant, he was not examined. The inquiry officer asked the presenting officer to present his case. After completion his submission, he asked the petitioner to submit his submission. While submitting the submission, while arguing the petitioner before the inquiry officer, the PO tendered document. These are the documents as exhibits. And that those documents were accepted as exhibit. PO they tendered it, below. That was not examined. Thereafter, what happened? PO, presenting officer informed the inquiry officer, I will tender 3 witnesses. PO inquiry officer allowed it, examined the 3 witnesses after completion of submission made by the delinquent. Entire process of inquiry is and therefore record is necessary. The lordship can examine it, and if it is correct, then the punishment as well as proceeding is liable to be satisfied.
where is the record?
Record is here probably. Let it be, make it part heard, let it be taken up next week, because my learned friend Goswami has some personal inconvenience of his medical leave. So can I have it, make it part heard, my lord? Otherwise,
Part of I will make. The top of the list matters. Why are you seeking adjournment? No, councils may have difficulties. We understand. But those days are gone. If a council is not available, the alternative council has to come in.
I understand.
We're not going to stop things. On Thursday, you show us the record. Heard Mr. S. Kotakil and counsel for the repetition. I also heard Miss
MS Sabina Ahmed. Sabina Ahmed.
MS Sabina Ahmed appearing for the respondents. After hearing submissions of the parties, it appears that perusal of the departmental records will be necessary for disposal of this repetition. As such, among the request of Ms. Sabina Ahmed, let this matter be listed again in the top of the list on day after tomorrow date to deal with, so as to enable the learned departmental council to present the records.
Obliged, your lordship.
May please, Lords. Well, matter pertains to pensioner benefit to the petitioner. My lord. The husband of the petitioner, my lord, was initially appointed as Sahayak in the year 1964. My lord. Thereafter, my lord, he was promoted from lineman 2 to lineman 1. My lord. And ultimately, he expired on 14/3/1990. My lord. But no pensioner benefit was provided to the petitioner. My lord. This is my.
Take your seat for a minute. I'll go through the synopsis. So what are the benefits you are entitled to, which has not been paid?
All the benefits, my lord, including DCRG, leave encashment, everything, my lord, including the pension. During pendency, my lord, I have collected some documents, my lord, giving pension to the persons, my lord, who were appointed during the same period of time,
No, one by one, please. Let us go system. Number one is pension.
my lord. DCRG, leave encashment,
Pension, DCRG, leave encashment, then
everything, my lord.
What
GPF,
else?
GPF, my lord,
yes. And
and GIS, my lord,
what is GIS?
group insurance scheme, my lord.
That is what, you are entitled to any amount for that, or that's just a coverage?
I'm entitled for that, my lord.
And what else?
And area pensions, my lord. Since 1990, my lord.
So this grievances against the APDCL.
My lord.
You are for APDCL?
They have filed an affidavit in the police.
Yes, Lordship. We had filed an affidavit, Lordship. It is paragraph 6, Lordship. It is clearly categorically stated, Lordship, that page 2.
Paragraph 6.
Yes, 6, paragraph 6, Lordship.
Yes, please read
Paragraph
it.
6, Lordship. The relevant portion is that, Lordship, in this regards, the deponent respectfully state that the husband of the petitioner was covered under the CPF scheme of the board. Board and H per provisions of CPF rules, no pension of family pension is payable to him. After the death of the husband of the petitioner, the CPF accommodation amount of rupees so and so, along with DCRG amount of so and so, totaling so and so, was paid to the petitioner by check number so and so, Lordship, on 3/7/1991, Lordship. Earlier, it was Assam State Electricity Board, Lordship, and date come service benefit of her deceased husband, so and so, and such the petitioner is not entitled to any further amount towards the service benefit, already paid, Lordship. CPF covered.
So
under
what about DCRG?
Yes, Lordship. DCRG has already been paid, Lordship.
How much?
Is amounting of rupees 28,356.10, totaling 88,129.20.
And leave encashment?
Leave encashment, Lordship, the affidavit is not shown regarding the leave encashment, Lordship, but so far submitted by the learned advocate of the petitioner, Lordship, these are not in his pleading, Lordship. Now he submitted that regarding the leave encashment and others, Lordship, but so far, Lordship, these regarding except the leave encashment, I have at this point, Lordship, I have not apprised before this honorable court regarding leave encashment, Lordship. But whatever he is able to get, Lordship, already paid, Lordship.
Then you argue your case established.
Well, I have some documents, my lord,
No, it is
of the
not.
persons who have
You
been.
can't give it like this. You have to file affidavit.
Then, my lord, I have today's time may be given, my lord.
Mr. PJ Sekal, learned counsel for the petitioner, submits that during the pendency of these writ petitions, certain documents have come to the possession of the petitioner, which is required to be brought on record in order to establish the claim in the writ petition. Therefore, he be granted 2 weeks time to file an additional affidavit. Mr. J.K. Goswami, learned SC APDCL, is present on behalf of the respondents and does not have any objection if the prayer is allowed. Although this is an old matter pertaining to the year 2012, yet considering the nature of issues involved in this proceeding, the prayer made by the petitioner's counsel deserves consideration by this court. As such, this matter stands adjourned for 3 weeks so as to enable the petitioner's counsel to file an additional affidavit.
I'm obliged.
All pending cases more than 10 years, 4 and 5.
Yes.
Yeah, please, Lord.
Who's for the respondent?
Respondents, government was there, madam. Lastly, Tishi Chutia
This
appeared.
today appeared, Lordship, he is coming, Lordship.
Yes.
Here, Lordship will find. Page 18 of Annexure 1, my lord.
What is the matter about?
My lord, this matter relates to selection and appointment of the junior accounts assistant, my lord, in the office of the Treasury Office of Tezpur, my lord.
Mm.
And under the deputy
Just for
commissioner.
a minute, please take your seat for a minute. And what is the other writ petition? Item 5?
Item 5 also, my lord, in the same, the selected candidate, my lord. They did not come earlier, my lord.
So you want that the earlier select list of 2008 should now be acted upon.
Yes, ma'am.
If there is any reason for them to cancel it, we'll close the matter. There is nothing. Because they can cancel a selection process,
Yes.
provided it is not arbitrary and not vitiated by malafide. So we'll ask them what is the reason it was done.
Yes, Lordship.
If there is a valid ground.
Yes,
at the end of the matter.
totally on the instruction of the irrigation minister that selection was cancelled.
No,
And,
inquiry was done. Inquiry was done
That
by the commission.
particular statement has been given in the impugn order itself on the instruction of the minister, madam.
Where is the impugn order?
Lordship, here in the affidavit, in earlier repetition, it is not there, my lord, only in the affidavit in opposition filed by them.
Hmm.
That is
Page number?
page number
1, 2, 3, and 6 and 7, my lord. Profile affidavit.
They filed the affidavit on 6/3/2009, my lord. At page 16, my lord.
Page?
page 16, my lord, 16. 12th November 2008.
Yes, please read it.
Dated 12th November 2008. So and so, whereas information was received from the Honorable Minister of Irrigation by his letter number so and so dated 12/10/2008, that gross anomalies and violation of existing rules and proceeding was committed in the selection of candidates for appointment of 10 numbers of junior accounts assistant and grade 4 for filling up vacancies in different treasury offices in Sonitpur district. In the same letter, the Honorable Minister ordered the Commissioner NND Tezpur to inquire into the allegation and stop the appointment process till the inquiry is completed in the interest of public. And where is under the number so and so dated 13/10/2008, the Deputy Commissioner Sonitpur was directed not to appoint any candidate until the inquiry is completed. And he was requested to produce all the connected files and papers and documents of selection of candidates for appointment for the post of junior accounts assistant and grade 4 in the treasury offices of Sonitpur district. And whereas I have gone through the files, papers and documents and found the following. The government of Assam in the finance establishment B by letter number so and so 1/2/2007 informed the Deputy Commissioner Sonitpur Tezpur that the government had approved for filling up grade 3 and grade 4 vacancies by direct recruitment in the district treasury sub treasury under the control of Deputy Commissioner Sonitpur as follows. Junior accounts assistant 10 numbers vacancies and grade 4 1 number vacancy. In the same letter, the government had directed the filling up of backlog of ST and PH physical handicap be given the first priority. The Deputy Commissioner Sonitpur by order dated 10/12/2007 at NS page 7 in file number STA establishment so and so ordered the Treasury Officer Tezpur to follow the government direction and to put up a draft for advertisement through Janasanjog. But instead of advertisement, the Deputy Commissioner Sonitpur, without any explanation, wrote to Tezpur Employment Exchange and Vishwanath Employment Exchange by letter number so and so 26/2008. The letter was signed by the Deputy Commissioner Sonitpur himself. But the forms for notification and the description of conditions which should have been enclosed in the letter of Deputy Commissioner Sonitpur was actually not enclosed. Instead of that, a general qualification required for junior accounts assistant and grade 4 post listing 13 numbers points was enclosed. It was signed only by the Treasury Officer Tezpur and the space for signature of Deputy Commissioner was left vacant. Deputy Commissioner Sonitpur did not sign the paper. At point number 8 of this instruction, the Treasury Officer sent a wrong information to the employment exchanges by stating that vacancies for SC, STH and HP were nil. But according to 20-point roster, there are 1 backlog vacancy for SC, 1 backlog vacancy for STH, and 2 numbers of backlog vacancies for STP copy include. In the 20-point roster prepared by the Treasury Officer, Tezpur at point 47 mean for STH, the Treasury Officer Tezpur has written vacant no STH candidate. And point 52 mean for SC, the Treasury Officer has written vacant no suitable candidate. A glaring mischief committed by the Treasury Officer Tezpur has been found here. It is because in the letter written to the employment exchanges, he had informed the employment exchange that there was no vacancy for SC and STH. Therefore, the employment exchanges did not send the names of the candidate of SC and STH. Secondly, it has also proved that Treasury Officer Tezpur did not prepare 20-point roster for ST and SC before conducting the recruitment examination. He must have prepared it after recruitment examination was held. The fact is that there are hundreds of STH candidates in Sonitpur district who always from the office of Commissioner NAD, other officers in Tezpur seeking for government job and plea that suitable SC candidate was not available, cannot be accepted in Sonitpur district. There are many of them. Whereas on examination of the file,
It is found that the order of the Deputy Commissioner Sonitpur dated 10/7/2007 at note sheet 7N. The DIPR is still in force. It has not been cancelled or modified till that. Not issuing advertisement through Janasanjog is violation of government instruction issued by Finance Department. By letter number so and so dated 1/2/2007. Advertisement is mandatory as per Supreme Court verdict, which has been written in the said government letter dated 1/2/2007. Paragraph. Whereas the Deputy Commissioner Sonitpur Tezpur by his letter number so and so 2/6/2007 requested the employment exchanges of Tezpur and Bishanath Charali to send names of candidates of at least 4 times of the existing vacancies of junior accounts assistant. But according to the present norms, the recruiting authority could ask for 20 candidates each vacant post from the employment exchange. Employment exchange Tezpur sent 190 names against 20 names as per norm. The ratio is 1:20. It is also seen that norms for notification under Rule 4 signed by the Deputy Commissioner is not found in the file. Government officer in the Finance Commission Department by letter number so and so 13 so and so approved for filling of 1 post of junior accounts assistant and grade 4 2 numbers after observing all required formalities as per the approved accorded by the Finance Department by their order under order number so and so 14/6/2007. No intimation has been given to the local employment exchange about the said vacant post. 1 number of junior account assistant and 2 numbers of grade 4 till late. And no advertisement has been issued till late, respectively, thereby violating the Employment Exchange Compulsory Notification of Vacancies Act as well as direction of Honorable Supreme Court in the reported 2006 4 SCC. On the other hand, Treasury staffs and Treasury officials might note dated 23/7/2007 at note sheet page 12N and 13 and misleading the Deputy Commissioner to fill up the said vacant post of junior accounts assistant and 2 grade 4 post. That is 1 peon plus 1 chokidar from the successful candidate of the written examination that will be held for selection of junior accounts assistant and 4 peon and chokidar. Necessary selection may be made from the same interview of grade 4 candidate. For which selection may be had, the Treasury assistant and Treasury officer white note dated 17/9/2007 of note sheet dated page 13, 17 and 18N. Note again, Mr. The Deputy Commissioner issued the appointment letter number so and so dated 17/9/2007. Appointing Sri Bhanakanta Gogoi as peon in Gopur Sub Treasury and Miss Nirola Soika as chokidar in Gopur Sub Treasury without informing local employment exchange, advertisement without police verification and without advertisement violating Supreme Court order. Hence, attracts punishment under relevant provisions of AFRMBM Act 2005. In this case, already Honorable Court has passed the order. It is seen that total 208 numbers candidate appeared for the written examination and 70 numbers of candidates were all for interview. A list of 12 numbers of application was forwarded by Assistant Director of Employment Exchange, Tezpur, by number so and so 13 July 2000. No mention about intimation to Employment Exchange, Gopur Exchange, which presently function from Bishanath Charali. A list of successful candidates is prepared, claimed to be in order of merit, and the ratio is taken as 1.6. This is 1:6. This is reflected in Treasury Officer Note that 22/2008 at note sheet page 22N. But relaxation is given in respect of SC candidate as a consequence of SC candidate Sri Sanjit Das. SC is deprived of opportunity. It is also not known how many physical handicapped candidates appeared for the said post. Total present absent general OBC, MOBC, SC, STB, STH is also not known. Physically handicapped candidate could have been in the merit list. From the note sheet at page 9N, it is seen that out of total post 23 numbers of junior accounts assistant, 13 posts had already been filled up. Vacancy position 10 numbers. It is not in the sanction post of Tezpur Treasury, including the Bishanath Charali, Gopur and Ramya subdivision. Sri S. Ahmed, Director of Accounts and Treasuries, Assam, has signed the minutes of selection committee without calling letters for holding a meeting, permission of selection committee, and without the decision of the selection committee meeting headed by chairman, that is the deputy commissioner. Director has accorded approval for filling up the vacant post of junior accounts assistant, violating instruction of the government. The Director of Treasury for approving it has violated the register point of Government of Assam Personnel B Department notification number 30th November 2005 and duly published in the Assam Gazette 6th December 2005 and reservation points the Reservation Act, including 120-point roster as per the provisions of Assam Services Act rules. Thereunder, there is no mention about compassionate appointment, if any. The director is also liable for punishment under the relevant provisions of AFRPM Act 2005. In view of so many irregularities and commissions and serious violation of rules and procedure, no order other than cancellation of the whole process of this recruitment will meet the end of justice and fair play. Cancellation is also required to maintain transparency of action of this government machinery. I therefore hereby cancel the whole process of recruitment to fill up 10 numbers of junior accounts assistant, violation of government letter number so and 1 post of junior accounts assistant sanction under government letter number 177/2007 for Gopur Sub Treasury and grade 4 staff sanctioned by government by letter number 1/2007 and another 2 numbers of grade 4 sanctioned by government letter number dated 7/7/2007 for which interview was held on 28/10/2007, 11/3/2004 junior accounts assistant by calling letter number and 29/8/2007 for grade 4. The deputy commissioner Soniku is asked to start the recruitment process afresh immediately by issuing of an advertisement by following the rules and procedure. Well, here they have said that the no advertisement, but as per the rules, Assam Treasury rules, 1993. Only the employment exchange, there is no such advertisement. And in this respect, in the similar circumstances, this Honorable High Court.
Mr. Khetri, see, these are matters where the law has substantially precipitated by now. You are also aware. The mere fact that somebody's name finds place in the selection list does not give a right to be appointed. That is settled law. You can't argue against it. Only thing is, if a select list is cancelled for any mala fide or arbitrary reason, to extend favor to someone else or to cause injury to somebody, then the courts can lift the veil and examine it. Otherwise, select list published, after that it can be cancelled. That is settled law. So the question here is, was the process cancelled in an arbitrary and mala fide with a mala fide intent? That's the only question here. Correct. Please listen, it will help you. Because otherwise you can make a submission, I can write the judgment in the chamber. But we don't want to do that because we are trying to find a solution if possible. If not, the matter has to be left. The law cannot be bent to suit somebody's interest, but if a person is genuinely deprived, then the courts will come into the rescue. There is no doubt about it. Here, it is a fact that the concerned minister has raised a flag. Correct. Ministers are all collectively responsible for the governance. But after that, an inquiry was conducted by the North Assam Divisional Commissioner. And he has submitted a detailed inquiry report, which goes to show that there were some anomalies in the process, in the sense that it has been mentioned that the advertisement was not issued, although there was a government directive to do it. Then SC/ST vacancies were not properly projected and some other issues. Now, if this is correct, then it cannot be termed as an arbitrary exercise.
To that extent, my lord, I understand. To that extent, my lord, when the argument was made during this hearing time, my lord, then my lord, the record was produced by the government advocates, my lord. And when the record was produced, my lord, then during the hearing time, my lord, the request was made by the council to the honorable court to have a look to the record, my lord. Then court permits me to go through the record, whether whatever the affidavit or whatever the allegation has been made, it's true or not, whether it reflects in the record or not. Then I have gone through the record, my lord. I have noted it, and I have filed the affidavit before this honorable court. Dito affidavit, my lord, whatever it was in the record, my lord, that affidavit has been filed in connection with another petition 941, my lord. I have filed affidavit, my lord. Whatever it has been said, my lord, it's not tell you with the record, my lord. Not tell you with the record. Only on the wisdom, my lord, they have
Let us see what is there in the affidavit.
lordship. The record will, the affidavit will say everything, my lord.
Just give me a minute.
That
Just give me a minute. Just give me a minute. Just give me a minute.
close to.
So select list was not published.
It was published.
It is not known whether the petitioners are selected or not.
Not
So it is possible that, assuming for the sake of argument, that if the court directs that the select list be published even today, none of the petitioners might get a job. That's possible.
not possible, my lord, since I have gone through the record, my lord, and record transfers, my lord, the petitioner's name, some of the petitioner's name are there
They are in what?
in the select list. It's a affidavit will transfer everything, my lord. That affidavit was filed on 3/10/2018, my lord, by MS Mitali Tamuli, my lord, in connection with 941 of 2017 case number.
I have one affidavit in reply dated 4th February 2020. Is that the one you are referring to?
One affidavit,
By
only it is
Social.
affidavit in connection with 941, my lord, WPC 941 of 2017. my lord.
Yeah, what is the date of the affidavit?
Filing is 3/10/2018, law. Next state petition.
Yes,
Mitali Tamuli law.
yes, please. Yes, I've got it. Yes,
May I read?
yes, please.
That I am the petitioner number 3 in the instance, para 1, madam. In the writ petition, this affidavit has been filed on the basis of information derived from the original record through the counsel of the petitioners to bring the material fact to the notice of the honorable court. It is stated that the original record produced by additional senior government advocate Assam before the honorable court on 27/9/2018 at the time of hearing of the case. However, as permitted by the honorable court, the counsel of the petitioner has gone through the official record inside the court and found the following materials of the petitioner selection hearing 2007-8 for the post of junior accounts assistant, in short JAA, as follows. That A, as reflected at page 7 and 10 of the note sheet of record on 10/3/2007 and 18/7/2007. It was found that the selection committee was constituted with the Deputy Commissioner Sonitpur, one nominated ADC SDO, member, director accounts. This is as per the rule, madam, and treasury officer, member secretary. It was stated thereof that out of 23 numbers of vacant posts of junior account assistant, already 13 posts were filled up with the position of quotas as mentioned below. ST Hills 5%, one number fill up. ST Plains 10%, one number to be filled up, and SC 7%, two numbers. And for OBC, MOBC, physically handicapped 3%, note sheet dated 30/4/2007. Further, it was stated thereof that ST Hills no backlog, ST Plains one number backlog, SC no backlog, OBC and MOBC no backlog, physical handicap one backlog. That at page 25 of the note sheet record, written examination of the for the post of junior accounts assistant was held on 28/10/2007 and viva versa on 11/3/2008. Accordingly, it was discussed with the Deputy Commissioner Sonitpur, chairman, and thereafter successful candidate's name was prepared in order of merit quota basis along with average marks of viva and total marks obtained. It was stated as per the that note sheet dated 29/8/2008, Finance Department's notification was received extending the validity for filling up the vacant post from 1/8/2008 to 31/12/2008. That at page 29, it is mentioned that serial number 1 evaluation sheet signed by the SDOs, namely DK Hendik and KK Vaishya. And at serial number 2 evaluation sheet, it was signed by the DC Sonitpur, that is chairman, director of accounts and treasury, ADC and treasury officer, all are complete members of selection committee, and also a list was put up, flag B. At serial number 4, a merit list was prepared on the basis of marks obtained by candidates in order of merit and roster basis, flag C, as per the record. As per note sheet of record in page 30 and 31, roster point was maintained after discussion. At page 34 of the note sheet, it was mentioned about roster point. As per roster and men in position. STP, as per roster 3 numbers, but men in position 4 numbers. The schedule caste 3 numbers as per roster, but men in position 4 numbers. STH 2 numbers and men in position 2 numbers. OBC, MOBC 6 numbers, men in position 7 numbers. Physically handicapped for 1 post was filled up by one BK Sharma, as mentioned at page 34. That at page 37 of note sheet of record, it is found that gradation list at flag X, roster point at flag Y, and WPT and BC letter dated at flag Z, and merit list of candidates at flag W. It is mentioned here in that at page 38, white note sheet dated 13/10/2008, it was stated that as per order of Deputy Commissioner Sonitpur, that is chairman, a final list as per roster was prepared and put up to him. It was mentioned in the note sheet that as per your order, that is chairman's order, a final list as per roster point is prepared and put up. At page 39 and 40, it was shown to be acute shortage of staff and requested the Advocate General Assam for disposal of the cases at the earliest. 6. That thereafter at page 142, 144, and 145 of original record, 100-point roster reservation was shown. However, at page 147, list of 41 candidates were shown among them. At page 137 and 148 of the list of selected candidates, with minutes of selection shown as below. List Miller, Sri Rajiv Nath is also petitioner Miller, Noyani Hazarika, and Ashok Basumatari, STP, serial number 41 of roster point. SC are roster point number 52, no suitable candidate. Kajal Kumar Nath, 6, Anupal Saikya, 7, Mrinal Kumar Bora, 8, Manas Jyoti Bora, 9 Srimati Ruby Bora, 10 Mitali Tamuli, and Gautam Hazarikama. It is to be mentioned here that though select list was prepared on merit cum roster point, merit list at flex C, note C of record at page 29, an evaluation sheet was also signed by all members and chairman of the selection committee by serial number 1, 2, and 4, including maintain of roster point at page 34 and page 37. A merit list was prepared and signed thereof. Flag W, which was not found in the record, and accordingly selection candidate minutes was prepared. However, for the transfer of the officers or for any reasons of the interference by minister or otherwise, the selection process cannot be washed out on such technicalities for not having the signature in the minutes of selection. Rather, it is required to be completed by constituting the committee to sign the minutes and further to appoint the selected candidates. There is no single whisper about the mala fide or irregularities in the selection after going through the original record, nor any such allegation against the selectee. That while the counsel of the petitioners went through the original record in the court room itself, as permitted by the Honorable Court, the flag B, C, X, Y, W, and Z are not found in the office record, which are necessary for the proper adjudication of the case. On the other hand, there is missing of pages from page 41 to 135, that is about 95 pages, where it might have been carried valuable note and other documents. The Honorable Court will look into the matter, and if necessary, the concerned official may be called for to appear and to reply with the up-to-date record before the surrounding court. In reference to the petitioner's RTI application dated 2/11/2016, the Treasury officer furnished the RTI reply dated 21/11/2016, annexure Z to the petition, wherein it was stated that all the documents in respect of recruitment process were kept under safe custody at strong room of Sonitpur Treasury in a sealed box, which cannot be opened at all. Hence, denied the information as sought for. If so, how the concerned additional senior government advocate opened the same without censure. Now, 8, para 8, that the petitioner stated that original record is found to be incomplete and lacking of vital note sheet and other documents. That is, from page number 41 to 135, about 95 pages are missing in the record. The official record is not in order. In this aspect, the Treasury officer may be called. 2. Minister's communication letter number so-and-so dated 12/8/2008 is not available, and there might be some other office notes in this regard, along with other discussion which is lacking in the record. C. Nothing has been found in record about the inquiry to be conducted, nor the report of Commissioner of Northern Assam Division, Tezpur, or the communication letter to the Deputy Commissioner with noting about the cancellation of selection process. As mentioned in note sheet, the evaluation sheet of the selection candidate signed by all members and the chairman of the selection committee is not found in record, flag P. There is no any gradation list, flag X, roster point, flag Y, C, WPT and so flag Z and D, merit list of candidate, flag W, merit list of candidate, flag W in the office record. The seal cover of the documents related to selection process was opened without the leave of the court, for which the office record is found not in order and missing of about 95 pages. G. The signed merit list is not available in record, flag W. It was nowhere stated in record that there was mala fide or irregularities in the selection process. The roster point was clarified, and thereafter prepared the merit list in consultation with the chairman and other members of the selection committee, as the plea of the concerned government is itself false and misleading. Once the merit list is prepared based on merit and roster point, the minutes of selection so prepared, but it was not signed. It cannot be washed out the enter selection on technicals. Rather, it may be directed to complete the same and appoint the selected candidate. Since the petitioner are also averaged now, and they should not suffer without having their fault in the selection process, that there is no justification to deny the appointment to those selected candidates whose selection was not vitiated in any manner, as reported in 2003-7 SEC 285 Union of India versus Rajesh PU Puthu Bhalkini Kathu and other. As per Rule 1993, and also reported in Uma Devi's case, para 6, and Tabzul cases in retapil number 258/2014 TV matter of this honorable court. There is no question of paper advertisement. Further, fair opportunity of hearing should be provided with principles of natural justice against the administrative action decisions while persons sought to be adversely affected. Reported in 2003 9 SCC 731 para 30. State of Maharashtra versus Jalgaon Municipal Council and others like the 2004 2 SCC 447 and 2002 3 SCC 496 para 10. On the other hand, court the decisions relied on by the government council are related to modified, unfair, dubious, and irregularities of selection, which are not relevant in the case because no irregularities are found in the selection process and evaluation of marks signed by the selection committee members as per the official record. That the Honorable Court by the order dated 2/8/2007 passed in WPC number 5108/2008, Roman Kultan, 2 others, State of Assam. By virtue of same inquiry report and termination order dated 12/11/2008, the petitioner were terminated for the LS irregular and illegal appointment, which has been set aside. Present petitioner are also in the against the same impugn or inquiry report and cancellation of selection dated 12/11/2008. Since the impugn order has been set aside by the Honorable Court in another case.
So you have the records, Mr. Chotia?
Yes, I have record. Malab, I have not gone through the record. Malab, today I have received it. Malab. Record is there, Malab. Malab, I will argue in this case, Malab. Malab, first thing is Malab.
No, let him finish.
Yes, yes.
And since my lord, in the affidavit filed by the respondent number 5, Treasury Officer, also categorically stated in his affidavit, my lord, that this selection was completed. Selection was done as per the merit and roster point, my lord. That has been in the RTI reply. It has been clearly stated, my lord. My lord, just I am reading, my lord, page 29 of the reply, my lord, of the affidavit, my lord, filed by respondent number 5. No, this is in my writ petition, my lord, page 29, my lord.
Para 8 of the respondent number 5.
In my writ petition, my lord. Yes. This office of the Treasury Officer, my lord, information under RTI Act, that information.
Page 29 of your writ petition in which proceeding?
This is the Arden 5210/2008.
Yes.
May I read those? Your letter number so and so dated 18/11/2008. Sir, with reference to your letter under reference, I am to inform you the following information as sought for. The information about the final result of the post of junior accounts assistant. The final process has already been completed. Result is delayed due to some inquiry. Reason behind the delay in declaration of the final result. The process was completed and the list of successful candidates were put up to Deputy Commissioner Sonito on 13/10/2008. In the meantime, as per direction of the Honorable Minister of Irrigation Assam, Commissioner North Assam Division Tezpur requested DC Sonitpur to send all files, papers, documents relating to the appointment of junior accounts assistant and grade 4 staff in different treasury officers and the Sonitpur district immediately for making inquiry into LS gross anomalies in the procedure of selection of junior accounts assistant under Sonitpur treasury establishment by letter number so and so 13 October 2008. The Commissioner NAD had requested BC Sonitpur not to appoint any candidate until the inquiry is completed. Process and basis of selection to the above mentioned post, that is junior accounts assistant. The whole process was done completely on merit basis and on roster point basis.
So, Mr. Chetri, you have to, I appreciate your argument, but there is one more hurdle you will have to cross. Supposing the court holds that the order of cancellation was bad, that would give rise to a situation where it will still be open for them, even if they publish the select list, to go ahead with appointment or not to go ahead with appointment. That the court cannot compel them. What do you have to say on that? We are going on legal principles.
Yes.
Because supposing it was not cancelled, even then, after publishing a select list, it is open for the authorities not to make appointments. The courts will step in if they appoint someone below in the rank by leaving aside people higher in the order of merit. Then it is a case of violation of Article 14 and 16.
From my true information, my lord, from the office of the Treasury officer, my lord, since this petition has contacted, and as per the information, this 10 numbers of posts still lying because of this court's order. And they say that as soon as any order comes from the court, because they have the scarcity of the staff's value. This is, they also wrote in the office note, and they say that as soon as any the court's order comes, that will be filled up, and it is lying there. So lordship will say, then he may obtain the instruction whether the posts are vacant or not. That information I have got, my lord. And now, my lord, these petitioners, they have hedged about 46, 47 like this. And they are even considering, lordship will consider that had there been a 1 year, 2 year lapse, then lordship may have considered to go for another selection. But otherwise, they have now crossed the limit. Now, unless your lordship.
And there is an interim order keeping the select list alive, is it?
No, that point, my lord, since already our honorable the apex court as well as high court, our high court also says, my lord, during the pendency of the select list, if the petition is filed, that will have the validity of the list, my lord.
Which is the judgment?
Yes.
So, Mr. Chutia, you have not filed any rejoinder to the affidavit, additional affidavit filed by the petitioner.
My lord, we have filed an affidavit, one treasury officer, one government, my lord.
No, this affidavit, additional affidavit filed on.
Yes, I think there is no matter rejoinder.
So there, whatever is projected, that runs counter to the findings in the inquiry report. Inquiry report says no reservation provision was made, but the affidavit shows there was no backlog vacancy.
Yes, my lord, I will show it, my lord. What is this? I will show it. Lordship kindly see. The first of all, the whole game is played by the treasury officer and keeping dark in the deputy commissioner also. Lordship kindly see our affidavit. That is their, my lord, first letter 26/2007 requisition. My lord, deputy commissioner Sonitpur, my lord, write to the wrote to the assistant director of employment exchange to send some to fill up the.
No, from where are you reading? From where?
Yes, yes, my lord, our affidavit, lordship kindly.
Which case?
In 5210 2008, Rajiv Nath.
Yeah, just a minute. Which decision you are relying upon, Mr. Chetri?
Yes, my lord, this decision, my lord, 2002 Supreme 162. And our High Court decision is also there to that extent. This is three judges, my lord, of the Honorable Supreme Court, 2000 to a Supreme and 162, my lord.
2003 SCC,
No, 2002 Supreme. May I supply the copy, my lord? On the basis of that, the Honorable Division Bench also passed.
yes, which paragraph?
Yes, my lord. Paragraph 8 and 10, Lordship.
Yes, what is the law, please? What is the ratio of this decision?
My lord, here it is said, my lord, I'm just reading, my lord. At the hearing of the Learned Counsel for the state of Uttar Pradesh, raised mainly two contentions. Firstly, para 8. Firstly, it was submitted that the select list having been prepared in November 1996 had ceased to be valid on expiry of 1 year from the date of preparation thereof, and an appointment from such list could not now be directed. Reliance has been placed on several circulars issued by the state of Uttar Pradesh from time to time, laying down the validity of a select list for appointment to state services at 1 year. Second plea raised on behalf of the appellant is that the respondent had filed the repetition by impleading only the state of Uttar Pradesh and UP Public Service Commission as respondent before the High Court, but had omitted to implead the High Court of Uttar Pradesh as a party in the repetition. As such, unbinding direction could be issued. As in the matter of judicial appointment, the state government is not free to act of its own unless until the High Court recommends an appointment so and so. We find none of the pleas, para 9, we find none of the pleas raised before this court was raised by the appellant before the High. A plea is to non-gender of a party cannot be permitted to be raised for the first time before the court if the same was not taken before the High Court and has not occasioned a failure justice. It is pertinent to note that High Court of Uttar Pradesh, through aware of the impugned judgment delivered by the division bench, has not chosen to file an appeal there against. Before us also, the appellant state UP has not placed any material on record to show an inference as to failure of justice can be drawn because of non-jointer of High Court so and so. As it pertains to the opinion, the plea of the appellant therefore fails. Similarly, the plea that a list of selected candidates for appointment to the state services remains valid for a period of 1 year only is primarily a question depending on facts, and yet the plea was not raised before the High Court. Secondly, we find that selection list was finalized in the month of November 1996 and the writ petition was filed by the respondent in the month of October 1997. That is before expiry of 1 year from the date of the list. Merely because a period of 1 year has elapsed during the pendency of litigation, we cannot decline to grant the relief to which the respondent has been found entitled to by the High Court. We may place on record that during the course of hearing of SLP before the court on so and so, we had directed the learned additional advocate general for the state of UP to bring on record on affidavit the status of present recruitment of the judicial officers and the present vacancy position in the subordinate judiciary. In the affidavit of Joint Secretary, Department of Appointment, State Government, Uttar Pradesh, sworn in on 4/11/99 and filed before this court, it is stated that on 14/10/99, there were 231 vacancies existing in the cadre of Munshi magistrates, now civil junior division. This being the factual position, we see no reason why the direction made by the High Court should be upset in the appeal preferred by the Uttar Pradesh. The appeal is therefore dismissed. The implementation of the order of the High Court under appeal was not stayed by this court. The appellant shall comply with the direction issued by the High Court within a period of 6 weeks from the day today, if not already complied with. This High Court was considered, my lord, and against that state of UP preferred an appeal, and that was dismissed. And on the basis of that, my lord, our honorable High Court division bench, my lord, just passed an order, my lord. Next, lordship will find 2003, my lord, by division bench, my lord, Muhammad Maidul Islam and others. Lordship has found it.
Yes.
My lord, judgment in pursuance of the selection process. My lord, short, I'm reading, my lord. In pursuance of the selection process, the petitioner appellant applied for the post of Lap Mandal for the amalgamated establishment of Deputy Commissioner Kokrajar. After following the procedure for selection of candidate, a select list was published by the authority on 28/10/1998, containing names of 22 candidates in order of merit. Although the select list was published, no appointment was made operating the select list, and therefore, before expiry of the life of the select list, the petitioner approached the court for seeking relief that they should be provided with the appointment in accordance with the select list prepared. The writ petition so and so was dismissed by the learned single judge on the ground that during the pendency of the writ petition, the validity of the select list has expired, and thus no direction can be given by the writ court. Agreed by the order dated so and so, the present appeal is filed. There cannot be any manner of doubt that mere empanelment or inclusion of one's name in the select list does not give any individual included in the select list to be appointed if the government decided not to appoint any person from the list for valid reasons. It is for the government to decide for valid reason to fill up the post or not, and no direction can be issued for operation of the select list, and consequent thereof to give appointment. Non-operation of the select list could be only on the ground which can be attributed to an non-arbitrary act on the part of the government. In the present case, although the government was noticed, no reply has been filed by the government indicating any reason for not operating the select list. In the state of UP versus Sarup Saros, this present, my lord, the case, while considering the aspect of life of select list, the apex court said that merely because a period of 1 year has elapsed during the pendency of litigation, it cannot be said that the court could not exercise the powers and issue direction in regard to the select list, which has expired its life during pendency of the court proceeding. But then the decision cited by the learned single judge for the purpose of saying once the validity of select list has expired, it cannot be given operation, on its reading does not apply in the facts of the present case. As in those cases, the government has taken a policy decision not to act on the select list, and accordingly, the select list was not operated. And consequent thereof, the court has declined to give any relief. Non-giving the relief is not the basis of the select list being expert during the pendency of the proceeding. In the present case, the admitted fact emerged clearly indicates that although the petitioner name were included in the select list, they have not been given appointment and the life of the select list expert during the pendency of the proceeding.
So, Mr. Chetri, you agree, and if you don't also, doesn't matter. Even if the court holds that the cancellation was bad, even then it will be open for the government to either go ahead with the same process which took place in the year 2012 or go for a fresh advertisement. That you agree. That is the law. You agree with that?
Yes, ma'am.
Yes or no?
That the government can.
You are a lawyer. You are not going to get the job. Don't be so. Assist the court.
Yes, that.
That you agree.
Yes.
So what is the stand of the government?
My lord, last is, I guess, rely on the case, my lord, this case is not applicable because. in this
Forget the case. What is the stand of the
The
government?
government state is, my lord, there is no advertisement, there is anomalies, enough anomalies. is
Mr.
there, my-
Chutia, if you don't answer the question, then we will have to seek assistance from.
No,
somebody.
regarding this, my lord.
Supposing the court dismisses, the matter ends. Supposing the court allows the writ petition partially by holding that the cancellation was bad. What is the stand of the government? In
No.
that case, would you go ahead with this election?
Definitely, my lord, definitely we will go for fresh advertisement, my lord, because there was no advertisement, we Google for advertisement. In fact, my lord, affidavit filed by the treasury officer, he has annexed one format, my lord. In format, lordship kindly see, first of all, lordship kindly see our affidavit filed by respondent number 1, 2, and 3.
Okay, so you are ready to make your final submissions today. You have to hand over the records, flag mark records.
This one record, my lord, I will have to go through it to assist the court, my lord, because I have not go through it. Voluminous record.
Then we'll take up tomorrow then.
Tomorrow I can do it.
Hmm.
Otherwise, my lord, from my affidavit, I can say I will go to the Orissa.
No, whatever you do, but if you argue today. Then we don't ask for adjournment.
No, I can argue on the basis of that, my lord. Affidavit.
It is up to you what you want to do, but you can't do it in piecemeal manner.
Record, my lord, I should go through it, well, because of the voluminous record. Whether it is cancellation
You
order.
have
is-
to show how the statements made in his additional affidavit filed in the other matter, 941, is incorrect from the records. If you can't show that, then the inquiry report goes.
Yes, I will go through it and additional
Because
affidavit.
you have not filed any rejoinder to the
Because, my
affidavit.
lord, this affidavit, I don't think, my lord, we have received or not, my lord, but it is not available in my file. Well, can he provide me, my lord, tomorrow I will give reply, my lord. Because.
Heard Mr. B. Chetri, learned counsel
I
for the
told you I did.
petitioner in both these
At
petitions.
night.
Also heard Mr. P. C.
Additional
Chutia,
affidavit.
learned additional senior government advocate
Additional
Assam,
affidavit,
who
no.
submits that he has received the records, but no copy of the affidavit dated uh, 3/10/2018, filed by the petitioners in WPC number 941 of 2017 is available in his record. In view of the above and on the request of Mr. Chutia, let these matters be listed again after tomorrow as fixed part-heard matters. A copy of the affidavit dated 3/10/2018 be furnished to the learned additional senior government advocate during the course of the day. Next, we'll conclude it day after tomorrow. You hand over your records with flag marks, etc.
As it is.
Fixed part-heard matters. Yes. Day after tomorrow.
Obliged.
Yes, what is the next one? After 5 minutes?
The matter heard by your lordship, and your lordship directed me to submit a list of dates, my lord. So I have given it earlier, my lord, one copy, you got it, I think. And along with some judgment, my lord. I have got two judgments, one of our own high court, on the point of 108 of Evidence Act, my lord, because the employee was missing for more than 7 years. So what is the consequence of that missing, my lord? In my case, my lord, my petitioner's son was missing. He was working in a special branch of the Government of India. My lord, at that time, the entire Bodoland was under turmoil because of this movement by extremists. And police has submitted a report after long gap, of course, my lord, that it is strongly suspect that he has been kidnapped by the extremist, my lord, because he was working in a special branch of the SIB. Thereafter, my lord, the departmental has initiated proceeding, ex parte proceeding during his absence and terminated him from service. And mother had no knowledge of this, his son is missing. And after long gap, he lodged an FIR. And my lord, thereafter, my lord, filed a writ petition, which is prayer to get the benefit of the son. That is my case, my lord. Now, the two judgments of our own high court, one judgment of our own high court, and my lord, it is Jammu and Kashmir and Madras High Court, my lord. And our high court has also decided this matter finally, that ex parte proceedings in case of Jammu Kashmir's case, my lord, he was working in the CRPF, he was missing, he has been termed as deserter, but the Honorable High Court has dismissed the decision of deserter and given the direction to give the benefit of our service benefit to the legal year of the person, my lord. And our High Court, my lord, in a Rekhamani Deka also, the teacher was missing, her husband was missing. After 7 years, the High Court has directed under 108, considering this, presumed him dead, to extend the benefit.
So, evidence actually. 1 minute, please take your seat. 1 minute.
Well, do you have the list of dates? Otherwise, I can provide.
No, it is not there. Perhaps
I'm giving
you can give a fresh copy. Mr. Biswas, please take your seat. I'll just go through the record once. Yes. What is the date of the ex parte order? In serial number 10, the date is not there. 14th of May.
99.
So he served for about 9 years.
Yes.
What is the benefit he is entitled to?
Pensionary benefits. Or anything deposited in his account, GPF. We pray for compassionate appointment of his any brother, that I leave it to your lordship.
Yes. Where is the order? Ex parte order?
Lordship, my annexer, page 9. My affidavit, page 9, annexer A. One thing just I want to point out, Lordship, this order, this dismissal is not for 31/7/98 for a previous occasion, Lordship. This dismissal order is not from the date as he presumed that he is missing, not for that unauthorized absence. This is a previous unauthorized absence.
That is correct, but when was this proceeding initiated?
This order is a 14/5/99, Lordship. Inquiry proceeding 29/5/97 charge sheet was submitted.
29.
Preliminary inquiry was fixed on 25/3/98.
So on the date on which charge sheet was submitted,
Yes, Lordship.
the petitioner would have to be presumed to have been
Lordship,
dead.
to that, what my submission is that, Lordship, the burden lies on them to prove that on that date he was.
Oh, no. Don't waste your time. You read 108. You have to show that he was alive on that day.
Because Lordship, now Lordship, kindly take annexure 5 of the writ petition, Lordship. Page 21.
Yes.
So as Sri so and so on 31/7/98 with the DAC main for FCP Dhonshiri has not reported at the post so far. Thus, he has been unauthorized absenting from duties so and so. He is hereby directed to resume duties and to hand over the DAC to the OC so and so. Forthwith, failing which departmental action will be initiated against him as deemed fit. This is on 26 August 98. The person has not returned on 31/7/98. Lordship, this is received by the petitioner and he had admitted of receiving of this letter, Lordship. This
This letter was received by the mother of
yes,
the
mother.
deceased.
But what my submission is that, Lordship, before passing the order of dismissal, Lordship, we have sent this to his home address.
Where is the order of dismissal?
Annexure, he had not enclosed it. Annexure A, page 9 of my affidavit. It's very clear, Lordship. After this also, we had sent 2 notices to him before passing the order.
You are not understanding. He went missing on 31/7/98. Anything done after that will be an action against a dead man, and therefore non-honest in the eye of law. As simple as that.
But the
You may send letter to his mother, his brother, his father-in-law, doesn't matter.
he is a habitual to absenting, Lordship. So this preliminary inquiry was proceeded against him. He appeared 2 occasions. On the last occasion, he had not appeared, Lordship. It is their case that he was dead on 31/7/98. As a
Ms. Sharma, don't be agitated. Be on the point. You are a lawyer, right? The law says if a person has not been heard to be alive by people who should normally would have heard about it for a period of 7 years, he will be presumed to have been dead. And the burden to prove that he was alive is on the person who asserts that. You have to prove that on 31/7/1998, he did not die and he is alive. If you can't prove, the matter ends there. He may be alive, but you have to prove that he is alive. That's the law. He has not been heard to be living by his mother, his brother, who are the people of his family members, for more than 7 years. Therefore, he has to be declared to be presumed dead. That's the law. If you say that he was alive beyond 31/7/98, which is a date after which his whereabouts was not known by anyone, then you have to prove it. If you prove it, then your order on that count may survive. But if you can't prove it, the order has to go because it will be an order against a dead man. As simple as that. Where is the impugned order? You said which page?
Page 9, Annexure A.
Yes. Yes, please. What have you got to say?
Lordship, I'm reading it, Lordship. Whereas so-and-so, is this article of charges, Lordship, Article 1, that she joins Chetri, Joy
So
Chetri.
what will we do it by reading this?
Lordship, I want to show that we have sent him letter to his address before
All
passing
right,
the
but
order.
Mr.
also,
SCB,
Lordship.
you will not understand. You have a right not to understand, but the court has a right not to waste time. Same thing you are repeating again and again. He was dead on 31/7/98. You have to prove that he was alive. Otherwise, everything is illegal.
Yes, one more point, Lordship.
Hmm.
That as per law, Lordship, if someone's wife is alive or his children are there, they are entitled for any kind of family pension. Although
That
here
matter we are not.
they have not claimed, Lordship. And mother is also getting family pension from her deceased
That is
husband.
another
also,
matter.
Lordship.
This order will be set aside. And you will be treated to be a dead person. Whatever consequences follows will follow in accordance with law. That's all. Take a seat. Yes, heard Mr. S. Business Learning Council appearing for the writ petitioner, also heard Ms. B. Sharma. No, what is the point you are trying to make?
That we came to know that this person is missing
How
only
does
after
it
10
matter?
years.
The law says something, we will only be concerned about the law. These persons' whereabouts were not known to anyone after 31/7/98. So on the lapse of 7 years, you will be presumed to be dead. You have to prove that he was alive. Can you prove it? Read 108. You must not have read it. That is the problem. Please read it.
Burden of proving that person is alive who has not been heard of for 7 years.
Hmm.
The question is whether a man is alive or dead, and it is to be proved that he has not been heard of for 7 years by those who would naturally have heard of him if he had been alive. The burden of proving that he is alive is shifted to the person who affirms it.
So are you saying he was alive? After 31/7/98, he was alive. Is that your stand? Yes or no?
Yes, Lordship.
Yes.
We are
Prove
not
it.
sure that whether he is dead on that
Oh, that
date or
doesn't
not.
matter. That's what the law says. Therefore, anything you are submitting is totally contrary to law. And hearing you on these points are wastage of time. You must argue on something which is legally admissible. If the burden is on you, it doesn't matter what you think. You have to prove it. You have to prove that he was alive. That's the law. The court cannot change the law.
Lordship.
You have understood?
Lordship.
That's why your preparations are on a completely different line, which will have no help to you today. So therefore, I said you take your seat. Yes. So and so, GC for the respondents. Full stop. The elder son of the writ petitioner, namely Joy Chandra Chetri, was appointed as a security assistant stroke G under the Subsidiary Intelligence Bureau (SIB) on compassionate ground, wide appointment order dated 10/1/1989. Full stop. Pursuant to the order of appointment, Joy Chetri had joined service on 03/2089. Full stop. During the course of his service, Joy Chandra Chetri was posted
At Kokrajhar.
at Kokrajhar. Full stop. Full stop. On 31/7/1998, Joy Chandra Chetri was entrusted with the work of delivering official duck (mail) close from Kokrajhar to Rongia FCP Deosiri DEOSIRI. Full stop. However, after Joy Chandra Chetri had left for Rangia on 31/7/1998, he went missing. Full stop. In other words, since 31/7/1998, the whereabouts of Joy Chandra Chhetri has not been known to any person, including his family members or his employers. Full stop. It is the case of the petitioner that since her son, since she was residing with her younger son at Sonitpur, she did not have any knowledge about the fact that her elder son, Joy Chetri, had gone missing while on duty. Full stop. It was only on 26/8/1998, upon receipt of a memorandum issued by the respondent authorities directing Joy Chetri to resume duty, that she came to know about the fact that her elder son, Joy Chetri, had gone missing. Full stop. Thereafter, several rounds of inquiries were made by her pertaining to her missing son, person whereto an FIR was lodged with the police. Full stop. According to the petitioner, even the employer of Joy Chandra Chetri, that is, who had lost FIR, respond number?
Your mother, my lord.
No, employer had also lodged FIR.
My lord, they also have lost the Annex 7 of my petition.
Who is the employer? Respondent number?
Oh, employer, the director of the special bureau, my lord.
Even the respondent number 2 had lodged a missing persons, had lodged an FIR with the police. However, despite all efforts to trace out Joy Chandra Chetri, he has remained untraceable till today. Full stop. Notwithstanding the same, the respondent authorities had initiated a departmental proceeding against Joy Chandra Chetri by submitting charge sheet dated 29/5/1997.
Lordship, this is by Assam Police Battalion, not by our side, Lordship. They had forwarded this to the Superintendent of Police, this Annexa 7.
No, he have also lost one FIR.
Annexa 7 is Commandant 7 FE Battalion. They have forwarded her petition to the SP.
Whose petition? Petitioner.
Petitioner's mother.
Your
petitioner.
side, you did not lodge any FIR.
No, Lordship.
Acha, ठीक है, then the respond number 2 part you did it. By submitting charge sheet dated 29/5/1997, whereafter an ex parte proceeding was held, which had culminated in the order dated 14/5/1999, whereby the son of the petitioner, namely Joy Chandra Chetri, was dismissed from service with immediate effect on the ground of unauthorized absence from duty. Full stop. Aggrieved by the order dated 14/5/1999. Now, assailing the order dated 14/5/1999, Mr. Biswas has argued that the impugned order has been passed against a dead person, and therefore the same is non-est in the eye of law, contending that the whereabouts of Joy Chetri not having been heard by the family members for more than 7 years, since 31/7/1998, she is liable to be declared as presumed dead as per section 108 of the Evidence Act. So under the circumstances, the impugn order dated 14/5/1999 is liable to be set aside and a direction be issued to the respondents to disburse the pensionary benefits, disburse the service benefits payable on account of Joy Chatri to his mother, that is the lead petitioner, and also pass an order for appointment of the younger son of the petitioner on compassionate ground. Full stop. In support of his above argument, Mr. Biswas has relied upon two decisions. Relied upon a decision of this court rendered in the case of Rekhamani Deka Das versus State of Assam and others, reported in WPC number 5665/2020, and another decision of the High Court of Judicature of Jammu and Kashmir, rendered in the case of Madhu Devi versus the Union of India and others. The third bracket OWP number 1440/2017. Full stop. Responding to the above arguments, Ms. Sharma, on the other hand, has contended that Joy Chandra Chhetri was a habitual absentee during the period of his service, and the departmental proceeding initiated against him, which had culminated in the order dated 14/5/1999, was pertaining to his period of absence from duty prior to the date on which the petitioner had gone missing. First up, according to Ms. Sharma, since the charge sheet was submitted against Joy Chatri on 29/5/1997, that is the period before which he went missing, the proceedings cannot be said to have been vitiated on any count, more so when notice of the proceeding was sent to the writ petitioner by the authorities, which fact is apparent from the mother received the notice, which fact is apparent from the pleadings in the writ petition. First up, Ms. Sharma has, however, fairly submitted that ever since 31/7/1998, the whereabouts of the petitioner is not known to the employer as well as the family members of that person. Full stop. Next, I have considered the submissions made by learned counsel for both the sides and have carefully gone through the materials available on record. Full stop. It is the admitted position of fact that on 31/7/1998, the elder son of the petitioner, Joy Chetri, who was serving under the respondents, had left Pokrajhar for Rangia for delivering official dak, and since then he went missing. Full stop. It is a matter of public. It is a matter. It is a well-known fact that around the time period when the petitioner went missing, the entire area of Pokrajhar, including the then Rangia subdivision, was under a turmoil due to activities, due to violent activities undertaken by the extremists. And during that period, several officials serving under various sensitive departments were either abducted or killed by the extremists. Full stop. There is also no dispute about the fact that the son of the petitioner went missing with effect from 31/7/1998, when he went to Rangia in discharge of his official duty. Full stop. Full stop. Section 108 of the Evidence Act deals with burden of proving that a person is alive who has not been heard of for 7 years. 108 to quote koi bole. Section 108. Full stop. By a plain reading of the provision of section 108 of the Evidence Act, it is apparent that since the family members of Joy Chetri, including the writ petitioner, had not heard of him of being alive since 31/7/1998 for a continuous period of 7 years, Joy Chetri would have to be declared to be a person who is presumed to be dead. But if the respondents, if it is claimed that Joy Chetri is still alive, it would be upon the party making such assertion to prove the said fact. First up. However, in the present case, it is not the assertion of the respondents that the son of the petitioner, Joy Chetri, is still alive. First up. Nor have they disputed that ever since 31, as noted above, nor have they disputed that since 31/7/1998, Joy Chetri had gone missing and has been unheard of. First up. In a decision of the High Court of Judicature at Madras, rendered in the case of N. Pankajam versus State of Tamil Nadu, it was held that once it is established that the petitioner's husband, so-and-so, State of Tamil Nadu, in a somewhat similar situation, it was held that once it is established that the petitioner's husband has not been heard for over 7 years with effect from a particular date, and the same is not in dispute, it is to be presumed that the husband of the petitioner is dead as per section 108 of the Indian Evidence Act. First up. Relying upon the decision in the case of N. Pankajam bracket Supra, a similar view has been taken in the case of Madhu Devi Supra, whereby it was held that the husband of the petitioner could be presumed to be dead full stop. On such declaration, the order issued by the authorities declaring the husband of the petitioner as a deserter and consequently dismissing him from service was quashed. Full stop. Next para. In the case of Rekhamuni Deka Das Supra, this court has also observed that since the missing person, that is the husband of the petitioner, therein was not heard to be alive for a continuous period of 7 years by invoking powers under section 108 of the Evidence Act 1872, he could be declared to be presumed dead. Full stop. Having regard to the facts and circumstances of the case, this court is of the opinion that the son of the petitioner, Judge would have to be presumed, would have to be declared as presumed dead under section 108 of the Evidence Act 1872. Full stop. Such declaration would obviously date back to 31/7/1998, which is the last date on which he was seen and or known to be alive. Full stop. If that be so, the impugned order dated 14/5/1999 was evidently passed against a dead person. Therefore, the order would be non-est in the eye of law and would be liable to be declared so by this court, notwithstanding the fact that the allegations contained in the charge sheet pertains to a period prior to the date on which the petitioner, the Judge Chetri had gone missing, that is 31/7/1998. Consequently, the impugned order dated 14/5/1999 is hereby set aside. The respondents are now directed to examine the claim of the petitioner regarding payment of service benefits on account of her son, deceased son, Judge Chetri, provided a proper application on that behalf is submitted by her within 6 weeks from today by enclosing a certified copy of this order. If any such representation application is submitted by the petitioner, the same be dealt with in accordance with law and the grievance of the petitioner be redressed as expeditiously as possible, but not later than 3 months from the date of receipt of such representation. With the above observation, this petition stands disposed of.
Your Lordship. May it please your Lordship, in this case, petitioner's grievance has been complied with by the respondent number 5 and 7. Petitioners are presently working as senior assistant in the office of the Directorate of Animal Husbandry and Veterinary Department, Kanikothi, Lordship. So petitioners approach the honorable court by this petition for a direction to be given to the respondent authorities so that they can avail the financial accounts training for which are helpful.
But you have to give me a synopsis, otherwise I will not take up your matter.
Lordship.
You have to give me a synopsis. Synopsis of the facts.
Synopsis is on the first part,
It
Lordship.
is there.
Yes, yes.
Just read it. How long is it?
Yeah, it is long.
On the prayer of Mrs. Dasgupta, and counsel for the petitioner, this matter stands adjourned for 3 weeks.
Lordship, I will pray for disposal, a short date may be given. Because it has already been complied with, Lordship.
Already been?
Complied with
Then you come up with a synopsis that 2 will dispose it of.
synopsis.
Yes. You
But
can't
no-
write a 5-page synopsis in single page.
Then Lordship, after 2 days, Lordship, I
No, no, no. Not after, next week.
next.
List this matter again in the next week so as to enable her to produce a short synopsis
A
of
date may
facts.
kindly fix, Lordship.
Miss
Kotoki for appearing for respondent 2 and 7, my lord.
Janet, the Standing Council Veterinary Department is present on behalf of respondent numbers 2 and 7. And Mr.
Lordship, P. Naik's name may be recorded.
P.
P. Naik, Lordship.
Mr. P. Nayak, the council is present on behalf of
3, 4, 5, and 6.
3, 4, 5.
My name may be reflected, my lord.
Date may kindly.
Is this matter again by reflecting the name of Miss M. Kotoki, Learned Council for the MM Kotoki,
MM
Learned
Kotoki, my lord.
Standing Council Veterinary and Animal Husbandry Department. Next week, not beyond that.
I'll
Sorry.
be on leave from 20th to 30th, Lordship. So.
Then you make a mention if it comes.
Okay, Lordship.
But this is regarding additional mondols, my lord. We are working in the post, my lord, since 93 or not, my lord. And in the meantime, some advertisement made, my lord, for post. In that way, we have come to your lordship. And your lordship passed order in order, my lord, on 10/3/2023. Not finished. So is it connected with those matters which were there yesterday?
That is something different, that matter. There are Gampras matters, and this is the Mondal.
Yes. Are you? Primary petitioner, your lordship, they are working as the additional mandal, my lord, and they are regularly selected and they are not appointed. Until that, they are working, my lord. And petitioner number 1, my lord, he will be retired in this. No, they appointed, no. Where is the appointment order? What process? You have to argue like that. You are as if chatting in a drawing room. That is not the way to argue cases. Appointed when? When was the advertisement issued? Show me that. Earlier on, my lord. Absolutely. Otherwise, you have no case. They were appointed, they are working, so they'll issue a mandamus. That kind of submission. Therefore, we have completed. I have not appointment letter. I have not given that. But where is the advertisement? Advertisement I have not any. Then we'll close it. These appointments are not valid. Then that is the law. But they have served about 27 years. Maybe, but who has appointed them? Against which post? By following what procedure? That you have to tell. Regular appointed. Therefore, they completed the RCC. You show it from the documents on record. Then we not. One appointment, one or two I have seen. Yes, but you must be right. Page 15 minute only. One minute. I'm coming. Mr. Page 15 you can see. In the interest of public service, the not is hereby appointed to the post of additional mandal in the scale of payments so plus allowances as admissible under the rules. Page 15.
The leave your.
And page 16 also similar, Millard, in the interest of public service, Sri Mananjan Majumdar is hereby temporarily appointed to the post of additional mandals. So was there any advertisement? I could not take an instruction on that point. Actually, earlier we also earlier approved this code, Millard, for the regulation of our post, Millard, and that order was there. Subsequently, this Millard, where we were working, and during working period, some posts were lying vacant. Those are those I have. So unless you show me what is the procedure, whether there is any advertisement, then otherwise I have to dismiss the petition. What is the way of? You are not willing to address the court on that. On some time, I will try to make it. On the prayer of Mr. A. Rashid, counsel for the petitioner. His matter stands adjourned for 4 weeks. Mr. J. Hendik, Learned Standing Counsel, Revenue and Disaster Management Department, and Mr. D. Bora, Learned Government Advocate Assam, are present on behalf of the official respondent. Mr. Rashid, come up with a complete case. You are seeking a mandamus. And they have filed affidavit. They have also not denied. They have admitted our case. Mandamus, you have to satisfy the court that your appointment was to a proper process. Then only there can be a mandamus. Because there is a parallel process of recruitment going on. It has to be quashed after 2 weeks.
Then 10 and 11.
So this is a two cases are analogous cases.
Before my learned friends start, my lord, IA 1932 is for impleadment.
We have no objection to that effect. Lordship has decided to dispose the whole case. That is why Lordship has.
Impleadment, who are you?
My lord, Their case is for promotion, my lord. The interim prayer was to keep one post vacant. And your lordship directed and that no appointment should be made without taking leave. On. Well,
May I submit?
So where is your IA? See the IA.
Operative portion is at page 15, my lord, last line.
You are one of the candidates.
My lord.
Take down, heard Mr. K. De Learned Council, this is IA number 1932 of 2023. Mr. K. De Learned Council appearing for the applicant. Also heard Mr. S.K. Goswami, Learned Council representing the P number 1 stroke read petitioner. Mr. R.M. Das, Learned Standing Council, Water Resources Department, Assam, and Mr. R. Dhar, Learned Standing Council, representing the Accountant General, Assam, are present on behalf of the other opposite parties. First up, by filing this IA, the applicant is seeking improvement in the connected read petition on the ground that the interim order dated 21/4/2023 passed by this court in WPC number 2125 of 2023 has affected his career prospect. Full stop. I have perused the amendments made in the application. Mr. Goswami submits that he would have no objection if the prayer for implement is allowed by this court. In view of the above and having regard to the statement made in the IA, this court is convinced that the applicant is a necessary party to the connected read petition. As such, the applicant herein, namely
Applicants, my lord.
the applicants, the applicants herein, namely the applicant numbers
13 applicant, my lord, and there will
1 to
be
13 herein
well, they will be respondent 6 to 18.
are hereby implemented as respondent number 6 to
18.
18 in the connected read petition. Now you have to, somebody has to file an amended cost title. The applicant to file amended cost title in the read petition being WPC number 2125 of 2023. IA stands disposed of accordingly. Amended cost title has to be filed.
It's a two analogous read petition.
Hmm.
One, they have filed an application for implement. Other, they have not applied for implement. My case is lordship like this. Lordship has already recorded in the last order regarding the controversy in this particular case. Cases like that, lordship.
So you don't want to file any affidavit, right?
Controversies like that, lordship. Petitioner, inquiry proceeding was initiated against the petitioner, alleging that some forgery has been committed by the petitioner. Thereafter, inquiry officer was appointed. Inquiry officer conducted the inquiry and given a report. In the report, there is a clear finding that they could not prove this allegation against me. On the basis of surmise, they have said that minor penalty was imposed, that loss of withholding of 2 increments in community benefit.
So this amended cost title has to be filed here. We'll take it up on Tuesday then. You file the amended cost title by tomorrow, day after tomorrow. We'll fix it on Tuesday. You had Mr. S.K. Goswami, Learned Council.
For final disposal.
Yes, yes. How many petitions are there? 2, 10 and 11. Also heard Mr. R.M. Das, Learned Standing Council, WR Department appearing for respond numbers 1 to 4. And Mr. R. Dhar, Learned Council for respond number 5. Mr. K. De, Learned Council has appeared for the newly implemented respondent numbers 6 to 18 and submits that the amended cost title will be filed within 2 days from today. In view of the above and on account of the urgency expressed in the matter by Learned Council for both the sides, registered to list both these writ petitions for admission hearing as fixed items on given 25/7/2023. These writ petitions shall be taken up for final disposal. Parties to come prepare recording.
Very quick, Your Lordship. Lordship, by this requisition, Lordship, the petitioners have assailed the promotion order of the respondent, Lordship, who are junior to the petitioners. Earlier, the petitioner was appointed in the year 2008 and the respondents were appointed in the 2010. Now, here are grievances that, Lordship, without confirmation of service of the respondent, Lordship, they have been promoted. But in respect of our Lordship, first we have been confirmed, thereafter we have been given Lordship promotion, Lordship. Now, Lordship, in the during the pendency of the petition, Lordship, they have again initiated, Lordship, may kindly please to take up the IA, Lordship. That particular letter has been issued on Annexa 1, page 75 in the IA. 8th of May 2023, whereby they again initiate, Lordship, process for promotion to this junior person for the next higher post, to this grade of APS junior grade, that is Deputy SP. But here also this letter has been issued against the rules. Lordship, kindly come to paragraph 5, the last sentence, Lordship, first paragraph. May I read this paragraph, first paragraph? With reference to the above, I am submitting herewith a list of so-and-so numbers of confirmed, unconfirmed inspector UB as per Annexa 1. Numbers of confirmed inspector AB as per Annexa so-and-so. These officers, this is important, Lordship, these officers qualify for the promotion as they fulfill the criteria mentioned in point number 72 of Assam Police Service Rules 1966, completing not less than 5 years of service. But this is against the rule. The rule says minimum 7 years of service. Now, they have reduced from 7 years to 5 years, Lordship.
So today you are finally arguing for disposal.
No, not for disposal, Lordship. Some protection is required because during pendency, Lordship, if they have given promotion, then this matter will influx of, Lordship.
No, but why can't we hear it today and finish it off? Writ petition, there are private respondents.
Yes, Lordship.
Who has appeared?
Notice have.
The persons who will be aggrieved if any order is passed in favor of the petitioners. And accordingly, Lordship, we have been directed to serve copies upon them. And it is not, the service is still awaited, Lordship. Some of them has been served, Lordship, but yet to be served some of the persons.
How many private respondents?
About nearing 60, 55 or 60, Lordship.
56. So we have been serving as, Lordship, Inspector UB. That's UB means unarmed branch, and the respondents are Inspector AB, armed branch, Lordship. And they are junior. Admittedly, they are junior. But if from the cadets only, it is, Lordship, clearly reflect, Lordship. Page 90. Page 90, I have annexed, Lordship. Page 90.
All right, now what do you want to show from this annexure 1, page 75?
Lordship, although, Lordship, they have taken step, they're saying that minimum requirement of service is 5 years. But the rule 19.6, it says minimum service is 7 years. So here's the rules, Lordship, they have issued. It is there, Lordship, in the manual, Lordship.
7.2.
7.2, yes. May I read, Lordship?
1 minute, 1 minute.
It was 7 years. No, Assam 1966. Assam Police Reserve Rules 1966, 7.2. 7 years.
7.2 की substitute.
I was full later. 8 years. Now again reduced to 5 years. Against the rule.
What will be 9 months?
It is true. It is against the rules. Process to
And where is the rule? Let us see.
Let's see. If some page 39. Page 39.
Yes, what do you have to say, Mr.
Lordship, may I pray, Lordship, they were Day after tomorrow, Lordship, as because why they have quoted this 5 years? As because it's in that act, Lordship, in that rule, Lordship, it is stated as 7 years. Earlier, it was 8 years, it was reduced to 7 years, but they have categorically mentioned in completing not less than 5 years. Why they have mentioned, let me obtain these instructions day after tomorrow, Lordship, within these 2 days, nothing will happen.
This is also my plan is that let them go ahead, Lordship, but that process shall not be finalized, Lordship. Nobody.
No, he is seeking 2 days time.
Lordship, let me obtain the
We'll have
instructions.
it on Friday then.
Lordship,
Take down.
let me get the instruction and thereafter, Lordship, if goes against the rule.
And Mr. A. Dekal, Learned Counsel for the applicant, peruse the statement made in this IA. Mr. Dekal submits that there is a completely anomalous projection in the communication dated 8/5/2023, bracket annexure 1, bracket close, whereby it has been mentioned that the promotion can be considered after fulfilling the criteria of 5 years of service in the rank of Inspector of Police, whereas the relevant rules prescribe 7 years of continuous service. Hence, an order of interim protection has been prayed for. Mr. Sharma, H. Sharma, Learned Additional Senior Government Advocate Assam, prays for posting this matter again on
Thursday or Friday as per your Lordship's convenience.
again on 21st of July 2023, so as to enable him to obtain clarificatory instruction in the matter.
Otherwise, also during pendency, Lordship, they cannot go ahead, Lordship.
No, that's all right. Are they doing anything?
Yeah, admittedly, they are junior.
Mr. Sharma to also appraise this court, whether any step for promoting the private respondents has been initiated by the departmental authorities.
Obliged. Diploma.
I'm praying for an accommodation of these matters for today, Lordship.
Final disposal.
Lordship, may take it up if possible on Thursday or any other day, Lordship.
This week we have already fixed. Next Thursday.
Lordship.
All right. Mr. M. Goswami,
Sharma.
MP Sharma, Learned Counsel for the read petitioners in this case, has sought accommodation on behalf of his senior
Lordship.
with a request to post these matters again on 27th of July 2023. Miss UFO,
I'm Jupiter Das for the respondent ICR.
Miss Jupiter Das, Learned Counsel for the respondent numbers
All the respondent of ICR.
for the respondent numbers 1, 2, and 3, and Miss M. Kalita, Learned Counsel appearing for the respondent numbers 4, 5, and 6 are present and do not have any objection if the prayer is allowed. In view of the above, office to list both these read petitions again on 27/7/2023 as fixed items. Part 2 here, Matu. Hearing list.
Part 2 hearing list. Item 1. 2 and 3. 4 to 8. 9 to 11.
You have for which case?
Lordship, actually, in the morning, in the mentioning time, our matter was 15 in the daily list. We are the petitioners. But we have come to know while going through the live streaming also, we have come to know that someone on our behalf have mentioned it, saying that they have already, like we are the petitioners and we seek adjournment of the matter. But actually, we have not, nobody has even taken the consent from our side. So while going through the streaming, we have come to know that item number 15, the Tiloknath, that is a long pending matter, 2010 matter, and it is part heard also. And my senior counsel, Mohanta sir, he was ready with the matter today. But unfortunately, like there was a mentioning done from someone's end.
Catch hold of him. You take the footage and catch hold of him.
Yes, we have seen it. There is maybe some Mr. Bora, I think.
Why is he mentioned then?
I don't know what was the reason, for what reason, like for the petitioners, it has been mentioned. Or maybe on the other, he has said item number 15. So it goes to us. And since the matter is part heard, it is very much important that it remains as part heard, my lord. That is what our.
It is part heard.
Yes, then we have no issue.
31-7.
Yes, ma'am. Only thing that we want to make the clarification that we.
I also do not have any. Maybe on behalf of private responding item number 2.
So we have not been actually, we have not given a consent. Nobody has informed us. That is the big problem now.
Order, no problem.
No problem. We have no issue.
All right, it'll come out after 2 weeks.
Yes, sir. Just we want to
But as part heard.
give the clarification.
As part heard.
Yes, yes.
Obliged.
So anybody ready with any part 2 hearing matter? Final hearing case? Today is a hearing day. Why people are not coming up to do hearing? I don't understand.